Hi, I'm John Kelly. I'm an attorney who's handling vulnerable adult cases. In this final chapter, we'll talk about the family's journey after suspected abuse or neglect, the emotional reality, the practical steps, and how the legal process weaves into the fight to protect someone that you love. Now, we've covered a lot of ground: the mechanisms of harm, the settings, the injuries, the evidence, the legal theories, the damages, and the defense tactics. Now we can step back, talk about what it looks like in real life. Because the truth is, these cases don't just happen in charts, they happen in families. And the family's journey often follows a pattern. Even though every story is unique, there's common paths. Phase 6, what the legal process actually looks like. Let's try to demystify it. Step 1, the consultation and intake. So as an attorney, I will listen first, not just to the injury, but to the timeline, the setting, the resident's baseline, and what changed. I will ask, what was the resident like before? What were their known risks? What was the care plan that they were giving? When did you notice the changes? What did the hospital tell you? What do you have for photos or logs, if any? I will also ask about powers of attorney, guardianship authority, which is the authority to act, and arbitration documents. For families, this may feel like a lot, but it matters because these cases are detail-driven. The second step, the records and early investigation. Facility cases live in the records, and as an attorney, I will often request the entire facility chart, incident reports, the care plans, MAR/TAR, wound documentation, weights, staffing records, and any available video. I may also request hospital records, EMS records, urgent care records, and prior baseline records. I do not delay getting out a preservation letter, which tells the facility to keep everything that they have in their possession. I'll often consider early on whether the resident testimony needs to be preserved. Video depositions, affidavits, or recorded statements, especially if the resident is medically fragile. Step 3, experts and theory building. A strong case usually involves early experts review. Why? Because the defense will eventually claim no breach, no causation, no damages. Experts help build a clean, defensible narrative early. This is what the facility knew. This is what the standard of care required. This is what they did instead, and this is how it caused harm. Step 4, filing and litigation. Once a case is filed, the defense responds. There may be motions, arbitration issues may be raised, corporate entities may try to hide behind layers. Then the discovery begins, and this is where the truth often emerges. Depositions can be hard for families. They can feel invasive. They can feel like the defense is putting the victim on trial. As a family member, you may be asked about why you chose the facility, how often you visited, what you noticed, whether you complained, and what your loved one's baseline was. Defense may try to imply that you didn't care enough and you were exaggerating, or that this is all just grief turning into blame. That's why preparation matters. Not coaching, just preparation. It's about being calm, factual, and clear. It's about saying, this is what I saw, this is what I documented, and this is what changed. As an attorney, we prepare family witnesses to avoid speculation, to stick to direct observations, and anchor their timeline. Staff depositions. These can be the heart of the case. Frontline staff often reveal the truth, even unintentionally. Questions that matter. How many residents were you responsible for? How often did call lights go unanswered? Were turning schedules realistic? What happened when someone refused care? How were aggressive residents handled? Were you trained? Were you supervised? Sometimes staff will defend the facility. Sometimes they will quietly admit systematic failure. We were always short. We did what we could with what we had. There was no time. Those statements are evidence. They show the foreseeability. EHR and audit trail discovery. In modern cases, EHR audit trails can show late entries, backcharting, copy-paste patterns, and changes after an incident. This isn't about catching people in a gotcha moment. It's about separating real care from paperwork after the fact. Step 5, the resolution process, settlement, mediation, or trial. Most cases will resolve before trial, often through negotiation or mediations. But facilities and insurers often test families' endurance. They will delay, they will minimize, they'll make it a low offer initially. A strong case resolves better because it's prepared for trial. Settlement should not feel like selling the loved one's story. It should feel like securing resources and accountability. Now, trial. When it happens, it's emotionally intense, but in the right case, it can be clarifying. A jury's verdict can speak for a resident who could not speak for themselves. If you find this information useful and you're dealing with any of these aspects that we've covered, please feel free to reach out to us at the Kelly Law Team. I'm an attorney that handles these cases across the nation. You can reach me at 602-283-4122.